Have you ever thought about bankruptcy? Welcome to Your Clear Thinking. I'm Roderick Mitchell, author of Credit Straight Talk, Clarity on the Conspiracy. I'm going to talk to you about bankruptcy. Bankruptcy in all forms is a very serious matter that should not be entered until every option is explored and fully understood. What I mean by fully understood is a complete explanation of the impact on your future if you do or do not complete the bankruptcy obligation. The forms of bankruptcy are Chapter 13, Chapter 7, and a combination of the two often referred to as Chapter 10. Bankruptcy should be your last option when nothing else will help you in your financial situation, because there will be repercussions whether or not you complete the bankruptcy obligation successfully. The difference is how severe will the repercussions be. The long-lasting negative impact on your credit rating is going to be there for 7 to 10 years, depending on the type of bankruptcy that you enter. It can affect your future credit, employment, housing, and your children's education. You will be required to complete a credit counseling course that you must pay for in order to receive a certificate of completion as part of the qualification for any form of bankruptcy. Failure to complete the credit counseling course disqualifies you to enter any form of bankruptcy. Let's start with Chapter 13, also called Debtor's Court. Chapter 13 is a plan to reorganize your past due debt. It is a form of protection from creditors pursuing repossession and foreclosure actions against you. You will be required to create a plan to repay your past due debt and submit it to the bankruptcy court. When an adequate plan has been submitted and approved in bankruptcy court, your recovery will begin. You will also have to continue your original payments of the obligations and pay the agreed monthly payment to stay in good standing with the bankruptcy court. When you complete your bankruptcy agreement obligation, you will be discharged from bankruptcy with a letter and certificate of completion. Failure to pay Chapter 13 payments or the original remaining financial obligation payments will violate the agreement and result in a dismissal from bankruptcy. The dismissal will allow you to be pursued legally by your creditors again. Next is Chapter 7 bankruptcy. It allows liquidation or repossession of the collateral connected to your financial agreement that was not paid in full. The income from the sale of the liquidated or repossessed item will be used to pay the balance that you owe the creditor. If the income received from the sale doesn't cover the entire balance owed, the creditor will have to accept the loss. You are free of all payment obligations once your case has been accepted in bankruptcy court. The only remaining penalty for you is that the bankruptcy will penalize your credit report for the next 7 years at least. The hybrid form of bankruptcy, often referred to as Chapter 10, is a combination of Chapters 7 and 13. You will reorganize the chosen debt into a payment plan and continue with your original payment agreement like in Chapter 13, making the original payments and your agreed bankruptcy payments you agree to. The delinquent balances of the unchosen agreements will be treated like Chapter 7 and discharged. The common use of this form of bankruptcy is to protect a home and a vehicle. It allows you to continue normal life and get rid of the non-essential debt agreements. The pros and cons of each form of bankruptcy will depend on your personal situation. Chapter 7 is the most devastating as far as surrendering everything, then starting over with a negative credit rating and literally no consumer credit at all. Your statute of limitations will begin immediately for Chapter 7 bankruptcy when it is accepted in court, and its negative impact ends sooner and cannot be restarted. Chapter 13 has a lesser impact in the sense that you keep the collateral as long as your agreed payments are made as agreed. Your statute of limitations will begin immediately when the Chapter 13 plan is accepted by the court. The default on the Chapter 13 agreements will result in a dismissal from the plan, allowing for the restarting of collection actions and a new statute of limitations. My personal opinion of a conspiracy type situation begins with the requirement for credit counseling. It demonstrates that an entire secondary industry is funded by consumers having credit problems. Bankruptcy attorneys are getting rich from a record number of credit consumers needing legal representation. Credit counseling instructors are being automatically included in all bankruptcy in all forms. Creditors are making record high profits without an end in sight. The perfect fit of this situation is too good to think it is a coincidence and just happens like this. The knowledge of consumer credit is effectively hidden from you until you have made mistakes that are profitable to the credit industry. If the subject of consumer credit was a required course of study in public schools, there is a chance that the record numbers of credit consumers needing any kind of bankruptcy would drop drastically. The need for bankruptcy attorneys and credit counseling could be cut in half because you would grow and mature understanding the vital role your credit standing will play in your future. In this episode, I talked to you about bankruptcy and some of the things you should consider before making that decision. Subscribe below and select the playlist to enjoy all of this series. I'm Roderick Mitchell, author of Credit Straight Talk, Clarity on the Conspiracy. Visit me at yourclearthinking.com and remember, together we rise.